Appreciate your argument, counsel. We will call the next case TEO versus Marco Rodriguez. Whenever you're ready, counsel.
May it please the court, my name is John Pierce, and I represent the appellant in the case, TEO. At the last moment, in preparation for the oral argument today, I discovered a case that I had not previously seen before that I want to bring to the court's attention. And
Have you filed a notice of supplemental authority?
Your Honor, I did not file a notice because I didn't find this until late yesterday afternoon, and I have given a copy of my material to counsel, and my request is that the court allow me to simply make the court aware of the case, leave copies here with you. In this case, which is right on point, there is a system that the Second District Court of Appeal used in deciding the case, and I made a copy, my copy of the computation for our case, and attached it to the court, or to the copy that I'm prepared to leave, and I have given all that to counsel, and
Why don't you tell us the citation of the case and then file a notice of supplemental authority with the clerk,
yes,
please?
The citation of the case is 44 Southern 3rd, 187, 2nd DCA. Case spelling is VELLETRI versus Dixon, DIXON, 2nd DCA, 2010.
Wasn't that case cited in your brief? I thought it was.
Your Honor, I don't believe so.
I know it wasn't cited in, I looked at that case this morning. I know it wasn't cited in the reply brief, but...
Here's a Dixon case, but not that.
yeah, there's Veltri versus Dixon, 44 Southern 3rd, 187 is on page 4 of 12 in your table of authorities.
Your Honor.
So you must have seen it when you wrote your brief, because it's in there, so argue away.
And that's what happened, Your Honor. I didn't see it when I wrote the brief, and I apologize to the court for the confusion, but my age is catching up with me, I think.
You're not the only one.
Pardon me?
You're not the only one.
Okay.
Catching up with all of us.
I do have copies that I'm prepared to leave with the court.
I've got the case here.
My copy, though, has attached to it the computation that is
okay.
Our case applied to the version that used here. And I would simply think that in analyzing this, it would save the court time, because it took me a considerable amount of time to go through the mechanics of doing that. So
Okay.
I will leave them if the court will allow.
All right, just leave them with the clerk of the court and ask them to get them to us. That'd be fine.
Leave them with the clerk, Your Honor?
Clerk, when you leave here today, just go out the door to your left and you'll see the clerk of the court's office.
All right, sir. Thank you for your understanding. Okay, this foreclosure case, Your Honor, on day one of the closing, the defendant was required to sign a promissory note in the amount of $300,000, but received only $70,707.98 in beneficial funds dispersed at the closing for the benefit of the borrower. Of the remainder of the total disbursement at closing of $87,900, the balance was paid as for benefits to the lender and is treated under the case law as interest, under the case law and the statute. The monthly interest as specified in the promissory note and the amortization schedule and the notice of payment stated very clearly that, and these were all of the original loan documents, stated very clearly that the interest payable was to be $3,247.50 per month. Nowhere in the loan documents was the borrower told that he could pay, that they could pay only 12.99% interest.
Let me ask you this.
Yes.
Can you explain to me, going beyond the computation and the amount of interest, because I get that they were paying, the documents indicate they're supposed to pay $3,000 and something per month for the extent of this loan, despite the fact that they didn't get all of the $300,000. But what is the argument, or where is the evidence that this transaction was entered into in bad faith? Because I think that that you have to show that the transaction was entered into at its inception in bad faith. And is there any evidence to suggest bad faith at the inception of this agreement?
Well, at the inception, Your Honor, it was the loan documents stated that this was supposed to be a construction loan. Only $70,000 was dispersed for the benefit of the borrower, and the monthly payments nevertheless were charged on the full stated $300,000 amount of the loan from day one through the end, according to the loan documents. Now, that's what this Velletri case keys on, is the fact that clearly makes this usurious. And
All right, but do those documents alone establish bad faith?
yes, Your Honor, I believe they did. There were no other documents. There was nothing else that occurred at the closing relative to this except to present the borrower with the note to sign, the mortgage, the amortization table, which showed the $3,200 a month required to be paid monthly, and a monthly loan statement saying that that's the amount that the borrower was to pay. Now, the lender here would have this court believe that if I wrote a note for 1% interest but charged $10,000 a month interest to the borrower and only dispersed $70,000 to them, that wouldn't be usury. And I think clearly it would.
Let me ask you this, because I'm not a mathematician. So this case was difficult to go through with the computations. But
yes, it is.
if they had dispersed the entire $300,000 at the beginning, would the $3,000 plus however much it was per month been within the less than 18%?
Yes, Your Honor, it would have.
So the issue is that they didn't, I guess, prorate that interest.
Correct.
All right.
They did not allow interest to be charged on the amount dispersed. They charged on the full amount of the loan, which was never dispersed.
But they went into, my question with regard to bad faith is this, but they went into the loan anticipating that they were going to be loaning them $300,000.
Yes.
Not that it was just going to be, they didn't foresee that they wouldn't get their permitting and therefore they wouldn't be able to make those additional draws.
That's correct, Your Honor.
And so I guess what I'm having a difficult time finding is where was the bad faith? The bad faith in and of itself because they were charging all of the interest to begin with?
Because they charged 100% of the interest on the full amount of the loan, whether it was dispersed or not. And everybody knew that at day one on the loan, only a small portion was going to be dispersed, and there was no schedule, no disbursement schedule of X dollars being dispersed on any given basis.
Well, I went back in the record today. There was a draw schedule.
There was a draw schedule.
What the draw schedule doesn't have are specific dates.
Yes.
It has benchmarks as far as the construction. You know, so you get so much when you get your permit. You get another so much when you get your slab poured.
Correct.
You get another so much when you got the exterior skin of the building up. You know, there was about 7 or 8 benchmarks.
Right.
Does it become a fact question? let me back up. It seems to me that in determining whether the loan is usurious, we have to say not what happened, but what was intended to happen if things had gone as planned. Do you agree with that?
Well, Your Honor.
So, just bear with me.
Yes.
If, for example, the evidence showed, and I don't know what the evidence would show, but just bear with me for an example. If the evidence had showed that, for example, they dispersed the $82,000 at closing, or $87,000, and they had, the intention of the parties was that they were going to disperse another $50,000 a month later, and another $30,000 2 months later, you know, that sort of thing, based upon those benchmarks. Does it become a factual question for the judge to determine what the parties intended to happen had things gone as planned? I mean, presumably your clients intended to get their zoning and build the building.
Yes, sir.
And so if they had gotten the zoning and drawn down the loan as anticipated, should the judge then go back and do a retrospective analysis and determine if the loan would have been usurious under that scenario?
Yes, sir. And the point is that in the case at bar where they charged interest on the full amount of the loan and not the amount dispersed from time to time, which would have been a very easy way to collect their 12.99% interest without question. All they had to do was say in the loan documents, the interest rate to be paid on a monthly basis will be 12.99 of the money you've received. That's simple. It can be varied monthly, and there would never be any question of usury. But here, instead, they charge the $3,200 monthly, no matter how much has been dispersed. And as I said, in the sample that I gave you, if I did a note with a 1% stated interest rate, but said I'm going to collect $10,000 a month, you would laugh at me and you'd say, get out of here, that's usury. Clearly it is.
Well, but the difficult analysis here is that we have to take into account the impact of the spreading statute, 68703, to spread out that interest over the anticipated life of the loan. And so what I'm trying to understand is, if, for example, there's no question that they collected interest on $300,000, or they charged interest on $300,000
Yes.
at the end of month one, even though they had only dispersed 80-something.
Right.
And on its face, that number looks bad. But they intended this loan to go for 3 years. Your clients intended it. Your clients probably intended, my guess is, looking at the draw schedule, that this was probably a 6 or 8 month construction period. So if the building had been constructed in the anticipated 6 or 8 months, and if the money had been dispersed according to that draw schedule, doesn't the judge then go back, using the formula that's in that Veltri case, and using 68703, the spreading statute, and say, well, if it had gone the way the parties intended, it either is usurious or it's not usurious? Isn't that really the calculation that's supposed to be done here?
Your Honor, the calculation that should be done is to charge the interest on the amount dispersed. And that's what they did not do.
Well, what authority is there that in and of itself makes the loan usurious?
It makes it not usurious if they charge the 12.99%.
Well, I understand that. My question, though, is the inverse of that. What evidence is there of the fact that it becomes usurious as a matter of law if they charge interest on the full amount on day one? If the intention of the parties was, I don't think the loan would have been usurious, for example, if the intention of the parties was that 30 days after the loan closing, they should have dispersed the other $220,000. So they got a little extra interest on undispersed money in month one, but the rest of the time they got the right amount of interest. I haven't done the calculation, but I don't think that would bump it up over the 18 or the 25%.
I would agree, Your Honor.
And so the fact that they may have overcharged in month 1 or month 2, I think that, isn't that what the effect of the spreading statute is in a construction loan? Is that you have to spread those things out, look at what the parties intended, and then determine whether it's usurious or not.
Your Honor, the difficulty here with the way this loan was structured is it was done wrong from the start. It was usurious from day one because they charged the full amount of interest no matter how much was dispersed. And no one is going to know whether it's going to take 12 or 24 or 30 months to disperse all of that money, or even if it's all going to be dispersed. They may have gotten some price breaks through construction and only had to draw down half of that money. Who knows? Those are facts that would have to be determined in the future. And if interest were being charged on the amount dispersed, then there would be no usury if it was charged at 12.99%. But when it's charged at the full $3,200, which is the maximum amount of interest on a full $300,000 loan, and that starts on day one, that makes it clear usury from day one, because there is no guarantee that that money is ever going to be drawn down. And in fact, it was not.
You've got 4 minutes left if you'd like to hold on to it.
I think, Your Honor, that we've covered the essence of my argument. The computations throughout the briefs are difficult at best, even for a good mathematician, which I supposedly was when I was growing up. And it took me a lot of time to go through this effort, and that was why I did this other attachment to the Belletri case to submit those copies to the court, because the mathematics in this thing is difficult at best. But that is a very well-reasoned case. It is directly on point, and I urge the court to consider that.
Okay, thank you,
Your
sir. You've got 3.5 minutes remaining for rebuttal.
Thank you, sir.
Good morning. Richard Glenn for the appellees. I think Jerry is actually correct that this Velici versus Dixon case is on point, because what it says, and actually it finds that the trial judge made an error in computing otherwise. It says that the issue of the computation of usury is to be determined at the inception of the loan, which is consistent with the cases that we cited in the brief, also consisted with Florida Statute 687, which says that usury must be computed on the assumption that the debt will be paid in accordance with its terms.
Well, let's talk about the terms here. The terms here were interest only for 3 years, right?
Yes.
$300,000, 12.99%. And yet when you look at, and I did the calculation yesterday, the $3,200 and whatever it was that was due is interest at 12.99% on the entire $300,000.
Yes.
So you agree that on when the first payment came due 30 days after closing, and they were obligated to pay $3,200, they were paying interest on money that had not been dispersed. I mean, that doesn't seem to be in dispute. Do you agree with that?
I would agree that if that were the case, that would be the case.
Well,
but
tell me why factually that's incorrect. They dispersed $82,000 or $87,000 at closing. And that's the only amount that they ever dispersed.
And if this had been an $87,000 loan, obviously that would have been.
I'm with you. I'm with you. But just bear with me. So we get to 30 days out, first payment's due. If they had paid in accordance with the loan documents, they would have owed you 32 and change, right?
If they had paid in accordance with the direct black letter provisions of the loan documents, yes.
Right. Well, hold on. Just
okay.
You agree that the note says that the payments are $3,200 and whatever it was, $3,250 or something, right?
Yes.
And you agree that if you do a mathematical calculation, that is 12.99% That's an interest based on a full disbursement of $300,000.
Yes.
Okay. So when we look at the Veltri case, and we look at the spreading statute, and we look at the Ham case that the Supreme Court decided, one of the things that Veltri says is, if a lender retains a substantial portion of the loan proceeds without allowing a corresponding abatement of interest on the amount retained, that retention effectively increases the interest charged on the amounts actually advanced to the borrower, which can render an otherwise proper loan usurious. So help me understand, and that comes from, a couple of Florida Supreme Court cases in their attempt to apply the spreading statute. Your client disperses $82,000 of a $300,000 loan, retains roughly $220,000, $222,000, which ultimately never gets dispersed, although I will concede that wasn't the intention of the parties.
Right.
Okay. But doesn't the Veltri case say that if you retain a substantial amount of the proceeds, that can effectively increase the interest rate, and you've got to take that into account in calculating whether the loan is or isn't usurious?
Well, you have to look at the intent of the parties at the time the loan was made. But if you look at the appellant's brief themselves, they go through the payments that were actually made. And I will tell you, there's nothing in the record that indicates what those negotiations were as to the payments. But Mr. Pierce kept saying that they were charged $3,400 a month. Well, in fact, they apparently weren't, because if you look at the payments, it starts in January of '08, which looks like a double payment then of $2,000, and then every month up until the time of the default about a year later.
Well, but aren't you comparing the terms, what they paid, what they actually paid, and what they were obligated to pay? When this trial, as I understand it, was conducted strictly based upon a submission of written documentation and argument of counsel. There was no no witnesses called, so we don't have to defer to the trial judge's superior position to assess credibility. We know what they actually paid, and we know what the documents required them to pay. In fact, when you sued them in foreclosure, didn't you charge the interest that the loan documents required them to pay? I mean, you pled your claim based upon what they should have paid, not what they actually paid.
Well, no, we based the loan based upon the amount they had been, the foreclosure, and the demand letter that was the led up to that. We did that based upon what was actually dispersed, not the entire $300,000.
Right, but as far as the payments due and the past due interest, that's what I'm talking about.
Not at $3,400 a month, but only the interest, the 12.99% on the $87,000. There was never, ever a charge made on $300,000. All of the payments, the demand, the foreclosure, the judgment, it's all just 12.99% on the $87,000 whatever dollars were dispersed.
Well, let me make sure that I've got the facts straight, though. We agree that the face interest rate on the loan is 12.99. Yes. We agree that at closing they dispersed 80-something thousand and yes, retained 220 more or less.
Yes.
And that the note called for them to pay $3,400 a month in interest only, and that interest equates to 12.99% of the entire $300, not just the money that was dispersed. I mean, that much I think we agree on.
Sure.
Okay. If the intention of the parties, and it seems to me that if you look, I went back and I looked at the record, and there's a draw schedule in there. I mean, clearly their intention was to build this building, and I guess zoning or something prevented them from doing it. Shouldn't the trial judge go back and say, well, if the intention of the parties, it doesn't specify that they were supposed to draw down this money a month later or 2 months later. It was pegged to benchmarks in construction. But if the judge looks at it and say, well, the intention of the parties was that they should have gotten this first benchmark in 30 days and the second benchmark in 60, and, you know, and assumes that the draws would have been made in accordance with the intention of the parties, doesn't the judge then go back and do separate calculations for each one and then determine whether it was usurious or not? I mean, if the intent of the parties at the outset is the operative fact.
Well, I don't know that you can make those computations and determine usurious intent from those computations. I mean, usurious intent is a matter of intent at the outset, and everyone intended that this was going to be a $300,000, 12.99% construction loan at the outset. So I'm not sure how you would go back there and determine that there was usurious intent.
All right, let me
Because
ask
of the
you.
fact.
Let me ask you one other question. Judge Berger was discussing with opposing counsel this concept of bad faith, or some of the cases referred to it as corrupt intent. One of the elements of usury is that you've got to enter into the transaction in bad faith or with corrupt intent.
Right.
And, you know, in trying to figure out what that was, I came across some cases, and this one that I'm looking at is out of the 3rd District, and I forgot my reading glasses, so I'm going to have to hope my arms are long enough. Sarah Leggetti versus Sacker, and what they said was, the element of corrupt intent does not require knowledge of the usury statutes themselves by the lender and a specific intention to violate them. Rather, it requires proof that the lender intended to collect payments for the loan, which, when expressed as a simple rate of interest per annum, exceed the maximum allowable rate. So, I mean, I interpret that to say that this concept of bad faith or corrupt intent means that you didn't have to intentionally set out to violate the law, but you had to intentionally enter into a loan transaction which violates the law. In other words, it can't be a typo or something like that. I mean, do you think that that's a fair statement of that bad faith or corrupt intent element?
I agree with you 100%. I think if the loan document on its face shows the interest rate is 19%, or there's going to be a withholding of some charge that's considered interest that will exceed that, I think on the basis of that loan document, the usurious intent can be determined. At least that's the way some of the courts do it. However, on the face of this document, this was, everyone agrees, the other side agrees, we agree, everyone agreed this was going to be a legitimate $300,000 construction loan. It was going to be well under the legal rate. So there's no way, from looking at the documents at the outset, that the court could determine that there was an intent to charge more than the legal rate based upon those loan documents.
But if there was not, but if the entire $300,000 was not dispersed in one lump sum, then going into the agreement, when there is a requirement at the beginning of the loan that they start paying what would be interest for the total amount, when the total amount was never intended to be given in one lump sum, why is that not meet the standard?
Well, that's arguable, and you know, the factually, you'd have to go into the next month and see what they were actually charged, which was not, I mean, if you want to...
Well, the loan documents say 32 each month for the life of the loan, so that's basically, I mean, I understand that they paid less, and apparently it seems like the bank was accepting less, but the documents themselves say 32 whatever per month.
If you determine, I didn't mean to interrupt.
No, you're good.
If you determine intent based upon the loan documents, it's clearly not usury. It's $300,000, 12.99%. If you're determining it from a later date, looking back, you can make that argument. If you make that argument, though, that factual argument, you also have to look at was actually charged, which goes back to the payments that were made that Jerry recites in his brief, which was based upon the amount that was actually dispersed.
Right, but there's no written agreement that was submitted into evidence for us to look at or anything other than the original loan documents. So there's nothing that says you're really only going to be paying this per month, other than the fact that it appears that was accepted.
Other than the chart, no, you're right. There's the mortgage, the note, there's the HUD statement, there's the draw schedule, that sort of thing. Then there are the actual charges. The actual charges were not based on $300,000. They were based on, and I understand that argument, but usury is determined at the time of the face of the loan. You know, if you want to go and look back, you know, I would suggest that there are the cases that talk about the usury savings clause, and you know that clause is used in cases like that where there's a question whether it's a close call, something like that. There is a usury savings clause in this mortgage and note that we discussed, but in that Velletri case, I believe, you know, the trial court apparently went to the time of foreclosure and was making that retrospective determination.
So your argument is essentially that if you look at what was actually charged for the interest, it was based on only what was dispersed, and if you go back and look at those calculations, you're saying that is clearly not usurious. Is that essentially it?
That's correct. And I'm saying as well that negates usurious intent if we're going to look at that.
Did the trial court make any findings as to that in the final judgment, or were there any stipulations, facts, because this was basically all stipulated to in terms of what the facts were?
It was
or
all.
Do we just have to look at the calculations and determine that for ourselves?
I'm not sure if I understand what you were saying.
You say that the interest was only charged on what was actually dispersed, so it can't be usurious. And that the calculations bear that out. Were there any findings by the trial court that the interest was only based on what was dispersed and the calculations show that it was not usurious, or is that just something that we have to look at through the calculations? Or were there any stipulations as to that when this was submitted to the court based on the stipulations?
That is in maybe Jerry can correct me, my memory's a little fuzzy, but that is based upon the documents that were filed in the court pursuant to the stipulation that the court looked at, and they were cited in Jerry's brief, and never disputed as to what the actual payments were. I think those payments were set forth in a deposition that is in the file, so there is record evidence of that. I don't recall, frankly, if the final judgment includes that. I doubt that it does.
Well, we understand there's no dispute as to what they paid, but I thought I understood your answer to Judge Sawaya's question that they were only charged interest on the amount dispersed. But the loan, I thought we agreed earlier that the note called for them to pay interest, every month. And so, for example, at the end of a month after loan closing, day 30 or 31, if they had paid in accordance with the loan documents, they would have paid $3,400 and change, which is not 12.99% of the amount actually dispersed. That is 12.99% annually of the $300,000. So I'm trying to understand which it is. I mean, they were either charged interest on the $300,000 under not what they paid, what they were charged. So is it, did you answer Judge Sawaya's question that they were only charged interest on the amount dispersed? Or is it correct, as I understood us, I thought we had reached an agreement earlier, and maybe I misperceived it, that they were charged interest based upon the entire $300,000 face value of the loan.
Well, maybe I'm getting confused. The loan documents say interest based upon the 300,000 because it's a note
Right.
based upon.
Right, we know that, but what were they,
But-
you said earlier they were actually and only charged for what was dispersed, the interest for what was dispersed. And you made that argument earlier in your presentation to this court. And now,
Yes.
is that what happened, or were they charged for the full interest for the full $300,000? Which is it?
Well, I'll tell you this, the Mr. Gendell's letter that's in the file, attorney's demand letter, that letter is based upon the $87,000. Interest was not being demanded based upon 300,000. The foreclosure demands interest based upon the 87,000, not the 300,000.
I know, but payments were made, weren't they?
Payments were made.
How much were the payments in terms of calculating the interest as to what was dispersed?
They were based on the amount that was dispersed. And here is a list of the payments. The first one was $2,000. That looks like a double payment because it is a multiple of two of what the balance of them were. $1,098, $1,066, $1,071.
Okay, if we calculate the interest on that computation on what was actually paid, what would the interest rate be?
These are payments that would be roughly, but they're all a little different, but roughly the 12.99% on the
And
$87,000.
again, I want to make sure you're telling this court that interest was only charged as to the amount dispersed, and that's it.
Yes.
All right.
I am telling the court that. To be clear, the documents obviously say otherwise because it was based upon a $300,000 loan. But the actual interest that was paid, the actual interest that was charged has always been upon the $87,000, never the other. The last thing that I would like you to consider is the fact that, these were investor loans. Home Equity, now defunct, taken over by the state, whatever made these loans, they were assigned basically to investors. And Chapter 687 very clearly states that the usury statute does not apply to loans that are assigned or valued, which these clearly were.
Last question, and you're out of time, but I'd like to ask you this. When I did a rough calculation a minute ago of what 12.99% would be on the 87,000 actually dispersed, it looks like it's around $940 something a month, which is close. Doesn't tie in exactly to those payments, but it's close. Is there any documentation in the file? There was no testimony. Is there any documentation in the file from your clients? Did they bill them every month for interest, for example? Is there anything in the file that would indicate that despite what the loan, the note said, that the intention of the parties and the effort of your client was only to actually bill them for the interest on the dispersed amount?
Unfortunately, no, because Home Equity was taken over by a receiver. And
they didn't get an interest bill every month or something like you might
There's
from a
nothing in
bank.
the file relating to that. The interest, the records, the accounting records always show interest charges based upon, the $87,000. Payments are based. They do exceed the 900 and something. I always assumed that must have been a late charge or something like that she included in those payments.
Is there an internal accounting document from your client that would show, for example, that they were only charging the $940 or $1,000 or whatever it was? If I go back into the record and look for that specifically, am I going to find anything like that?
I'm embarrassed to say that I don't have that on my tongue. I believe that you will, but I would hesitate.
Why was that? It seems to me that that's a pretty important point, and this was based on stipulations submitted by the parties. Why wasn't that, put in the stipulations and made clear to the trial court. Don't you think that's a pretty important point?
Well, I think that's important. I had always,
I mean, no, you didn't think it was important enough to
well,
put into the...
in my mind, I had always viewed the payments that they made and the charges as being one and the same, so making the distinction as to what they were.
So you're saying that you just looking at the payments that were made and doing the computations is easy enough, and you didn't have to put it into the stipulated facts?
Right, that there would have been, if these had been insufficient payments, there would have been a demand or a foreclosure long before the payments were actually stopped, as opposed to...
Well, opposing counsel's got his calculator out, and he's busy calculating, so he maybe...
All right, well, we'll give opposing counsel a chance to sum up.
I've got it.
I gave your colleague an extra 3 minutes, so if you need that,
Do you
because we
agree-
can't get enough of usury cases.
Do you agree with opposing counsel that, I mean, I think he's made it clear to us, because we asked him enough time, that interest was only charged on the amount that was dispersed?
Absolutely not,
Well,
Judge. Nowhere in any of these documents is there any calculation of interest or a calculation that arrived at the amount of those monthly payments. And in fact, those monthly payments varied throughout the course of the 12 or 13 months when they were paid. They
I have
varied.
a document it looks like it's page 699 of the record, and it's Home Equity Mortgage Corp. payment history, and it lists, date paid, due date, payment amount to principal to interest, late fees and all that. And it says in January, it looks like, going back from the 2007 up through 2009, with total interest in January of 08 of $1939.54, February $1,005 in interest, then in March it looks like $967 or $969.77 in interest, and then $900 basically, and then some late payments. So this document appears to show that interest was charged in around $1,000 to $900, $930, $960 range. What document is this?
That document was produced at the deposition of the person who took over the management of this after the circuit court in Dade County took the business away from the lender because they had committed all kinds of criminal acts. So when that receivership was started and a party was appointed, a company, B&Z was the name of the company, was appointed to take over the business, that is when that document was created, and it is a history.
Okay.
That's not something that was created ahead of time and sent out, or that was sent out monthly. There were no monthly payments sent to my client ever.
Okay.
No record.
I was just trying to figure out what that document was.
That is what that document is.
Okay.
It was produced by the representative for B&C at the time I took his deposition.
well, if that document says that the payments of interest were something like $900 or $1,000 a month, would that basically compute to somewhere around 12 or 13% interest on the amount that was actually dispersed?
Sir, I just did a calculation on the amount of interest that at the payment of the amount that was dispersed for the benefit of the clients was $70,000 and change, not 87. The difference of $17,000 was interest, extra charges paid to the lender at the time of the closing. So the amount on which the client received
Okay,
benefit,
well, do the computations exceed the amount of the usurious rate or not?
the interest calculation based on the $70,000 that was dispersed for the benefit of the clients, the $50,000 in cash that they got, and the other $20,000 that were standard closing costs that are chargeable to the client. That interest totaled 17.1% in round numbers when I just did this calculation to arrive at what we
Yeah,
were
but
talking about here.
the loan discount fee, the 16,000 or 16,500, that difference,
Yes, sir.
the law requires that that be included as an interest charge,
Yes, sir.
which I think makes your case better, not worse.
Yes,
I mean,
sir.
I calculate the interest on the 87,000 at something like $940 a month, but
And when you calculate the interest on 70,000, the interest rate goes to 17. That's
well,
what I'm
and that's
saying.
not and that's not usurious.
Well, no, sir, it isn't, but that's not the whole story either. That doesn't include the benefit of the other additional money that is chargeable as
But
interest.
if the trial, if as the trial court found, there really was no intent to charge a usurious rate when the documents were originally entered into, and then after it became apparent that, the disbursements of $70,000 or $80,000, whichever it was all that was going to be dispersed, and there was an effort on the part of the other side to reduce the interest payments to at least below the usurious rate, how then can you claim that there was this is a usurious loan?
Your Honor, these people who ran this company left the country when the state of Florida took over their business. So we couldn't depose them, we couldn't get any evidence from any testimony from them. They were responsible from day one for preparation of all of the documents, and the documents didn't say they were going to charge interest only on the amount dispersed. It said the opposite. It said they were charging interest on the full $300,000.
But apparently, according to opposing counsel, and what we learned from you now, that they were only trying to charge interest on the amount that was dispersed because they weren't charging the full amount under the loan documents, were they?
Sir, no, sir.
Okay, well,
The amount that was paid was the amount that my clients wrote a check and delivered to them. There was no bill sent for the amount of those payments. There is no billing system. They had no billing system apparently because there was never a bill sent. So the amount of the charge was what's reflected in the closing documents. There is nothing else to show what was charged. What we're talking about here is what was paid that came out of that history document.
All right, sir, you've exhausted your time. Thank you so
Thank you.
much. All right, we're going to have a panel change at this point, so we'll go ahead and take a morning break and invite counsel to join us in the Lawyers Lounge for coffee.